for inviting me and for all of you attending. I appreciate it. So tonight's agenda, we will be looking at the No Surprises Act, the protections that patients will be receiving regarding provider directories, continuity of care, and a few other good things that are good for you to know this year. So let's start with the No Surprises Act. The No Surprises Act did go into effect January 1st, and it allows protection from certain surprise medical bills, and we'll be looking at that in a little more detail going forward in terms of exactly what types of bills it will protect you from. And the type of plans that the No Surprises Act covers is actually quite broad. It covers plans that are issued, health insurance plans issued by groups, employers, marketplace plans like Covered California, and individual plans as well. It does not apply to Medicare or Medicaid, but that's because the protections that are afforded under the No Surprises Act are already a part of those plans. So let's look at what's covered. Primarily, and this really goes to the heart of the legislation, emergency department services, because the majority of surprise bills that people receive come from when they are taken by ambulance or otherwise to emergency departments. It's an emergency, you don't have time to find an in-network hospital, so you find yourself at an out-of-network hospital, and then you're hit with out-of-network bills. The No Surprises Act stops that from happening. It stops emergency department services, excuse me, that you would receive from hospitals, freestanding emergency rooms, or urgent care centers that are licensed to provide emergency care. Only the urgent care centers that have that license. So those are the facilities that have to comply with this new legislation. You're also protected from out-of-network charges that you may have received in the past from in-network hospitals. This was also fairly common. You'd choose an in-network hospital, you'd have surgery, let's say, and then you'd find out that the anesthesiologist or radiologist was out of network, and you would receive those out-of-network bills. This legislation stops that from happening, saying that you cannot receive out-of-network charges from these providers that are at in-network hospitals. It also covers air ambulance charges as well, but it doesn't protect you from everything. So what's not covered? It does not cover ground ambulance charges. So, and the reason for that, you may be saying, well, if I'm protected from out-of-network bills for air ambulance, why not ground ambulance? And that's because ground ambulance operations and ownership is very, very complex, and who runs the ambulance companies depends on where you live. Sometimes it's the fire department, sometimes it's the city you live in, sometimes it's the government or a private ambulance company. So because it's so diverse and so complex, the legislators weren't able to come up with a policy that would cover all of these different types of ambulance companies. So for now, if you are taken by ambulance and it is out of network, you will not be protected from those out of network charges. Nor will you be protected for non-emergency services that are provided to you at the facilities that are listed here. Clinics, birthing centers, addiction treatment facilities, nursing homes. And here you'll see the urgent care facilities. These are obviously the urgent care facilities that are not licensed to deliver emergency services. So how does this legislation work? How does it really protect you? So what I'm going to list here or talk about here is what's considered the floor, meaning that states can provide more protection, but the federal government has listed these protections. So this is the least that states and providers can do. So the patients will only pay in-network rates for out-of-network services at the facilities and in the situations we've just taken a look at. So In addition to not having to pay out-of-network rates, the good news is you're paying in-network rates, and those out-of-pocket costs will go towards your deductible, your out-of-pocket maximum for the year, which typically does not happen with out-of-network payments. So it's kind of a double win in that regard. So if you're not paying the bill, then who is? The insurance company and the provider will negotiate the out-of-network charges. And ultimately, the insurance company will pay the bill. However, if the insurance company and the provider can't agree on what the amount of the charges should be, then they have to go to what's called an independent dispute resolution. It's like an arbitration process, in that both parties attend the arbitration, they present their side of the case, if you will, their facts, and then the arbitrator will make a binding decision. And it's this independent dispute resolution part of the bill that has actually been the subject of lawsuits that were filed last year, even before this law went into effect. And at the heart of these lawsuits is where the negotiations over price begin. The No Surprises Act language says that no particular weight or presumption for any one factor will be used as a starting point to discuss how much a service should cost. In September, that should have said 2021, excuse me. In September of 2021, the Biden administration issued a ruling that said that arbitrators would lean towards the amount closest to the insurer's median in-network rates. Many providers had an issue with this because they said it places a heavy thumb on the scale. So the plaintiffs that you see listed here are the ones who actually filed lawsuits against that rule, saying that in fact it was in violation of the original language. In February of this year, the judge sided with the Texas Medical Association and really invalidated the rule. So there will be more to come on that. But the good news is patients' rights will remain protected no matter how these lawsuits come out. So I mention it only so you know what's going on a bit in the background, but the patient's rights will remain in place. So that's a good thing. However, there are a couple of watch-outs that we need to be aware of. The first one is the one in which patients can waive the protection that is afforded to them under the No Surprises Act. Now, there may be a time when a patient wants to use an out-of-network provider, and that's okay, but it's important to know that they are doing it only when they choose to and that they don't inadvertently do so. So the protection can be waived only if the provider gives written notice to the patient at least 72 hours before the patient receives the services. The notice has to be in easy to understand language. Now, in part, easy to understand means that the notice has to be written in the 15 most common languages in that region. And the notice also has to identify the out-of-network provider's name and the services. And if, let's say, there are two providers who will both be out-of-network for this service, the names and services of both providers need to be included in this notice. It has to explain exactly what care will be considered out of network, and that in fact the patient has the right to obtain these services elsewhere, meaning there may be in-network providers that the patient could choose to use. The notice also has to provide a good faith estimate of charges. And most important, this notice has to be signed by the patient in order for it to be valid and for the protection to actually be waived. Also important is this notice has to be given separately to the patient. It can't be buried in a stack of paperwork the patient is otherwise given before the services. It has to be separate. The patient can refuse to sign and say, no, I do not want any out-of-network services or providers. And in that case, then the provider can cancel the service, but they cannot charge the patient any type of cancellation fees. So it's important to know all of these rights. And there's one more watch out to be careful of with this law, and it's about post-stabilization. If a patient is in an out-of-network hospital and as part of an emergency situation, and if they become stabilized and their provider decides that in fact the patient can be moved to an in-network facility, it's that post-stabilization period where charges can be incurred if the patient doesn't go to the in-network facility. So they're in an out-of-network facility, they don't want to be moved, then the protection stops at that point. However, the doctor can't just say, well, we're going to ship you over to this facility. These are the steps that have to be taken in order for this post-stabilization period and the transfer to take place. The provider has to determine that the patient can travel to this in-network provider, and in doing so, the transportation has to be non-emergency medical or non-medical transportation, meaning a bus, a car, a cab. It can't be an ambulance. And the patient can consent, meaning that they're well enough to understand what is being proposed and to be able to respond. And again, the provider has to give the patient an estimate of what the out-of-network fees will be if the patient remains at this out-of-network facility. And finally, the patient has to consent in writing to remaining where they are in the out-of-network facility and not transferring to another one. So there's a lot going on here, but it's something to be aware of. So if you're an advocate for someone or if you're the patient, make sure the person who is advocating on your behalf knows these requirements and make sure they are followed and adhered to. In addition to these two watchouts, there's also a loophole, because what's a law without a loophole, right? A key part of the No Surprises Act, as I mentioned earlier, is that it protects patients from out-of-network costs in emergency situations. So there could be a situation in which the insurer denies that this situation was an emergency. And in that case, then you end up in this tug of war between the insurer saying that the situation was not an emergency and the hospital that was potentially treating it as an emergency. And Harley was kind enough to share an article with me about a couple who actually had this happen. It was the birth of their premature twins who were in the NICU for a period of time. And their insurance company said this was not an emergency situation. And this couple had an $80,000 out-of-network bill, which it took them over a year to resolve. But a lot of that time was spent trying to get the medical records from the hospital to the insurance company. And there was a lot of back and forth and finger pointing. And it took that long, but they did finally get it resolved. So we don't know yet. It's too soon to know how often the insurers may make this determination, but it's important to know that it could happen. So if it does, if it happens to you or a client or a patient of yours, keep requesting the hospital documentation. Even if you're getting a lot of mixed messages, it's not coming through, keep requesting that documentation. Because what you want to do is file a formal appeal with your insurance company to say that in fact it was an emergency, and your medical records, ideally from the hospital, would be the medical proof to prove that it was in fact an emergency situation. If the appeal fails, there are three places where one might file a complaint and have the situation reviewed again. They're listed here: the California Department of Insurance, Department of Managed Health, or the No Surprises Help Desk. So these are all places where you can go if you are unable to get your insurance company to reverse their denial. So let's see now about a good faith estimate, also in terms of what happens. This is another protection that is part of the No Surprises Act that is actually for uninsured patients or those who are self-pay. And the self-pay patients may be those who have insurance but are choosing not to use it. So those folks would receive the benefits of this good faith estimate. With this, the provider must include a description of their services and the charges that they will be giving this patient for those services. It's the estimated charges because, of course, they're not going to be final until afterwards, and we'll talk a bit more about that. The good faith estimate is not limited to facility-based care only. In fact, the good faith estimates need to be given to patients by both the providers and the hospitals that are involved in delivering the care. This does not apply to Medicare or Medicaid because there is not a need for a good faith estimate with those coverages. So let's see how this actually works. The notice that in fact a patient is entitled to receive a good faith estimate must be posted at the provider's facility or website. So this might be a hospital, it might also be a doctor's office. And again, just like with the other notices, you'll see that this notice needs to be clear, understandable, and prominently displayed and easily searchable if the provider has a website. So this needs to be there and available and understood by the patients. In addition to the notice just being posted, though, the provider has to ask if the patient is insured or if they will be using insurance. And if the answer is no, they are not insured or they're not going to use it, then the provider must issue a good faith estimate, and the patient doesn't have to ask for it. In fact, if the patient just generally asks the provider, gee, what will this cost? Do we know what this will cost? That is enough of a question to trigger the provider needing to issue this good faith estimate. So the burden rests very heavily on the provider. So here's a little bit more about how it works. When the service is scheduled, that is when the provider needs to give the patient this estimate, and it needs to be provided to the patient within 1 to 3 business days of either the service being scheduled or the patient just asking how much it will cost, because the patient may not be ready to schedule it yet. They may want to look at the cost first. So from that time, they ask about it, they ask about the cost, or they schedule it. The estimate has to be provided within 1 to 3 days. I had mentioned earlier that this is an estimate of the costs that are given before the service obviously is given. If it turns out that the final charges are at least $400 more than the estimate, the patient has the right to dispute the charges. But there's a few things to know about that. There is a $25 filing fee to file this dispute, and it must be filed within 120 days of the billing date. And the link is here where a patient could go to actually file that complaint. It's good to keep in mind a possible defense that might be coming from the provider is that something came up that was medically necessary during the service that could not have been anticipated beforehand, and therefore it was unanticipated costs and services. So that might be one defense, but nevertheless, there is at least a dispute process that a patient can go through. So beginning next year, there may be additions to this good faith estimate, and some of these possible future additions may come as early as January 1st of next year. And that is when all providers and facilities that may be involved would need to issue these estimates. And the way that's different than what it is today, if you go to a hospital today and you ask them for this cost estimate or they issue it, they will issue it to you just for the facility. It will not include all of the provider's charges that would be involved in the particular service. But January 1st of next year, this protection may be expanded to the point where the hospital then would need to include not only their estimated costs, but also the estimated costs of all of the providers that would be on your team. So that's one change. Another change that may happen, although there is not an anticipated date yet because it gets pretty complicated, is that eventually this good faith estimate that is now just a part of the protections for those who are uninsured or not using insurance, that it will eventually be applied to insured patients as well. So basically anyone would be entitled to get an estimate of costs. But if you have insurance, it would work a little bit differently. The provider would actually give the cost estimate to your insurer, and then your insurer would look at how much your deductible would be, if you've met it, what your out-of-pocket max would be, all of your out-of-pocket costs. They would add that to the estimate of cost, and then they would issue you or the patient what's called an advanced explanation of benefits. As you probably know right now, you get an explanation of benefits after the fact, showing how much the costs are and how much the insurance will pay and how much you will owe. Well, in this case, it would come out before the service based on the provider's estimates. But again, that's in the future. We don't know when it will be happening, but it might be coming. So all of these protections that I've just gone through were part of the Consolidated Appropriations Act. And there are two other protections that are a part of that act that I think it's important for us to know. And we're going to look at each one of those. But first, let's look at the Consolidated Appropriations Act in general. And again, its reach is quite broad. These protections apply to these plans, individual plans, employer plans, non-government plans, and church plans. So again, a lot of plans are having to comply with these. Because these laws are fairly new, and no one can anticipate exactly how they will work once they're actually in operation, we expect that there will be further regulations and clarifications coming down the pike in the future that will issue more direct guidance in terms of how to operate with these. But for right now, the insurance companies and the plans have to use, quote, good faith and reasonable interpretation. So we hope they are reasonable and it's done in good faith. So the first of those protections is about provider directories. You may have had and probably have had experiences similar to the ones I have had, where you call an insurance company to ask if a specific provider is in network, whether it's a doctor or a hospital. Very often, the rep would say, look it up on our website. And they would not tell you whether or not that provider was in network or not. And if it turns out that the provider you thought was in network was actually out of network, the insurance company would say, not our fault. Even if their information was wrong, they would say, you should have asked the provider, it's not our fault. Well, all of that changes now. And insurers are now required to update their directories every 90 days, which I think before they probably only did it about once a year. And if you call your insurance company and you ask if a provider is in network, they have to respond to you within 1 business day. And the response can no longer be, look it up on the website. They have to tell you if that provider is in or out of network. And this is the part that I love. If the enrollee is given incorrect information, then he or she still only pays the in-network cost sharing portion. The insurance company can no longer come back and say, it's not our fault, it's your fault. No. The patient now only pays in-network. And if the patient has already paid the provider an out-of-network balance, then the provider has to reimburse his or her patient for the overpayment. So there's a lot of changes there, and ones that I'm really happy to see, because I've had patients really get into some trouble over this. So it's a good thing. The second protection has to do with continuity of care. This is another that just has been a real problem for some people. In that very often you may be receiving ongoing treatment and you start near the end of the year, you cross into the new year, you continue to receive that treatment from the person you thought was in network, but as of the first of the year, they moved out of network, but you didn't know that. So suddenly you have bills for this care that you thought were in network and now suddenly out of network, and you're on the hook for those. While this continuity of care portion and protection of this act actually provides patients a temporary period of time when they can continue to receive services from a previously in-network provider who has now moved out of network. They can continue to receive services from that provider, but only pay the in-network cost share, which can be quite a savings. But like everything else, there's a lot of rules that go along with this. It doesn't apply to everyone in all situations. It only applies to certain patients who are receiving what's defined as continuity of care. And those are these 5 sub-bullet points I have listed here. That the patient has to be undergoing a course of treatment for serious and complex conditions, or they have to be inpatient or in a facility, or they have to be scheduled for non-elective surgery, or they're pregnant or terminally ill. And it's only if you or your client or your patient fits in one of these categories that they then can be protected under this continuity of care provision. If they do qualify, then the burden again is on the insurer, and this is what the insurer must do. They have to notify the patient of the provider's change in status. So no longer than would a patient just be surprised 3 months into the new year that their provider went out of network in January. The insurance company also has to inform the patient of their right to receive transitional care, and they only charge the patient in-network cost share for this period of time that they're covered. And this temporary period of time can only go up to 90 days after the notice is provided or until the patient no longer qualifies. So I would strongly urge anyone who receives this protection during the 90-day period that they use that time then to either find an in-network provider, or if they want to stay with this now out-of-network provider, that they look at what the cost will actually be and see if they are able to financially meet the out-of-network charges that will be coming their way. The providers cannot send the patient a balanced bill. So you've got an out-of-network provider who is now only receiving the in-network contractual rates, well, they cannot balance bill the patient. So there is no surprise bill there. So those are the new legal protections that hopefully will save a lot of people from getting surprise bills. But there are a few more good things I want you to know while I've got you here. Just in general, even beyond what we've talked about here, whenever you're dealing with insurance plans, insurance benefits, words matter. It is so important that you get and you keep your plan documents. You know, these are not exciting things that you're going to curl up and read in the evening like a good book, but they are really important that you have them, because if you challenge a decision by the insurance company, whether to deny a service or not pay a bill or pay only a portion of it, decisions around those issues will turn on the language that's in the plan document. That's always the first thing I ask my clients for is, I'll need you to send me your plan document, because those are really the rules of the road. Whenever you call your provider or your insurance company, document the phone conversations. Make note of who you talk to, when you talk to them, the date and the time, and what they said. And if you don't understand what they're saying to you, or it's just not making sense, ask for clarification. Ask and ask again. Believe me, I do that, and I just did it the other day with a rep, and I said, you know, that just isn't making sense to me. Let's go back over this again. So keep them on the phone until it's very clear to you what they're saying, and keep your notes. Because if you do file an appeal or a grievance, those notes will be extremely important as you build your case. Because yes, the devil is always in the details. And of course, as you probably gathered from this, if not from your own experience, what you're going to need is patience and perseverance, whatever you're dealing with insurance companies. If you talk to 10 different reps, you're going to get 10 different answers. So be prepared for that. And again, if what they're telling you doesn't make sense, ask more questions until it does. They're called customer service reps. They're there for you. Don't let them go until you understand what they're telling you. So just be prepared for a long, complicated, illogical journey. Think Mr. Toad's Wild Ride. That's what I think of often when I call these places. So those are just some notes, some final thoughts, and I do have my blog on my website that's listed here, where I provide information now. Once a month, I post a new blog with some updated health insurance information to help you make good choices. So there you have it, and hopefully we have time for questions.